all of you, if any of you have participated in our webinars before, I think you're aware of Angela Davis and the fantastic job she does. She's a partner and founder of the firm Gerard and Davis, and is a Gerard and Davis helps support the ACCG HR helpline. So without further ado, Angela Davis.
Well, thank you, Dan Beck. Good afternoon, everybody. It's great to have you with us on this beautiful day, because I can imagine you might want to be easing outside about now. So appreciate you hanging in the office and tuning in for this primer on workplace violence and weapons policies. And frankly, I hope that I'm not going to lead you to want to engage in any workplace violence or to find a weapon after this is over with. But I'm going to try to keep it entertaining and informative, and we'll spend the next few minutes talking about what I think is an increasingly important and relevant topic. Okay, hold on just one second, because somehow I lost my share screen. Can y'all still see my PowerPoint, Dan?
Yes, you got to go back to the other version. So if you switch sides, right there you go.
Okay, so hopefully I've got it here. So, so without further ado, let's just jump in. As I was saying, I think this is really a perfect time for us to be talking about these issues. Workplace violence and weapons policies are things that have been out there, and you may have old policies in your books, or you may not have a policy. But if you don't, I think the time is now to revisit this issue and to address it. For those of you who are in the HR field, you probably don't go a day without speaking about COVID. And I spoke to an HR director actually yesterday, and she said it's sort of a game in her office. If they can get through the day without uttering the word COVID, then somebody gets a candy bar. So that might be fun for your office as well. But she said it's never happened, because there's always an issue about a leave or a benefit, or, you know, something to do with application of their policies with all of these new issues presented by COVID. And we have labored through all of those, some on these webinars, and I know you're doing it every single day. But this is one of those maybe more attenuated issues that's very real in this COVID area. Because now, as I'm sure you maybe feel personally and you've seen in your workplace, the COVID issues, and now that we're entering into literally year 2 of these issues, is really taking a toll on people. Increased stress, increased isolation and depression. There's all kinds of studies about depression correlating to quarantine and not being able to be engaging in your daily walk of life and daily entertainment and daily work practices. And all of these things contributing, of course, to what's coming into your workplace every day, whether it be your employees or whether it be your customers, i.e. the citizens that are coming to seek your services. So it really is an important time, because we're at an all-time pressure cooker point with our general public and with our workforce. Now, sometimes these present in, you know, fatalities in the workplace. So the ultimate serious workplace violence issues. We don't have numbers for 2020 right now, and frankly, those would probably be down because people were not in the workplace as much during 2020. But for 2019, I wanted to share this statistics with you. So of the 761 fatalities, people who lost their lives in the workplace from intentional injury, 454 of those were from homicide, so your shootings, and 307 of those resulted from suicides that occurred in the workplace. Now, while that is dramatic and it's serious, you know, a lot of different variations of that happen that are very important, and even maybe not as dramatic, but just as important for your workplace. I wanted to highlight a couple of these 2019 events. One happened in May of 2019 in Virginia Beach. And I'm highlighting these because I'm going to ask you the question. And if we were all sitting together and I could look at your smiling, beautiful faces, I would ask you to raise your hands and we would have a little better interaction on this. But I'm going to share the scenario, and I want you to think about, okay, you know, could we have prevented that? What could we have done in our workplace? So in Virginia Beach in May of 2019, it's shortly after 4 o'clock on a Friday afternoon, and a city employee comes in and just starts shooting, and sadly kills 12 people. One of those was a contractor who was trying to get a permit at this municipal office building. The 11 others were city employees. The employee who did the shooting was a certified professional engineer in the Public Works Department. He had worked for the city for about 9 years. He had resigned his job by email earlier that day, but he was under no investigation, not at risk of losing his job. His personnel file showed him to be a satisfactory employee. There were no issues going on in the workplace, nothing that was known. According to the subsequent police investigation, there was no documentation of threats or verbal or physical encounters with this individual, with the at the workplace, or with the individuals whom he shot. And there was never a determination as to what the motivation was. So on that one, I ask you, could you have done anything? You might not have been able to foreshadow that situation. Now, maybe you could have done something through your workplace safety policies that could have minimized the damage, but probably couldn't have prevented it. But let's look at this next one. This happened in Winston-Salem, North Carolina. In this scenario in 2019, and these are real events, 6:37 in the morning, a sanitation employee comes to work. He had been working for the city for about 20 years. And he had been working for about 12 years. His coworker had been at the city for 20 years, I'm sorry. And apparently these two individuals had a long-standing dislike for each other. It was known in the workplace that they were basically enemies. They had gotten into a physical altercation off city property the day before, engaged in like a fist fight. And then that was not reported. Nobody reported that. So neither side, the victim, nobody acknowledged that in the workplace or reported that to supervisors. Then early the next morning, one of the individuals involved in the altercation comes with a gun and shoots his coworker. Fortunately, the loss of life was limited to that one person, but unfortunately, any loss of life is obviously too much. That's a situation where you ask yourself, well, could we have prevented this? And I would say maybe, maybe not, but there's certainly some issues here that as we go through our time together today, I want you to start being aware of. There's a long-standing feud that's known. They're enemies. They have, physical altercation off the property. Those are the kind of things that maybe gives us some red flags and some warning signals. And so we'll talk about those as we go through today. Now, workplace violence generally can be grouped into 4 kinds of violence. There's the criminal intent type. So, you are carrying on your business and somebody comes in from the outside with no legitimate business relationship and just comes to commit a crime or other criminal act. The second would be a customer client type. So maybe someone comes in and say, let's just give a wild example. You've got a builder or contractor who's unhappy because they can't get their permit or they've been issued a stop work order. They're your customer, but they come in disgruntled and upset and they engage in violence in the workplace. You've got the coworker type where, as I gave one of the examples, you have one worker having an issue with another worker and engaging then in violence in the workplace. And then there's the personal relationship type. And this is not really that uncommon either, where maybe the perpetrator doesn't work in the workplace, but his domestic partner or personal relationship individual is in the workplace, and that person's coming in to your workplace and engaging in that violence. And many times that's in a domestic type situation, domestic violence situation. So we're going to focus on coworker type workers violence here today, but I wanted to mention those other types because many times they get overlooked. I mean, we certainly aren't going to necessarily be able to legislate those in our workplace violence policy in our handbook, of course, but you should be aware of them because to the extent many of you in the HR field may also double as risk management individuals or have some kind of risk management function, then you should think about general workplace safety, and those other issues are issues that you should have just kind of top of mind and keep in your thoughts as you plan for safety in the workplace. So now I want to give you the overview of what we're going to do today. These are the lines of defense. And I really do think when it comes to workplace violence, you can't always know what's coming at you, like the examples I gave you of those 2 shootings. One may be predictable, one entirely unpredictable. So you really just have to be able to play defense and be able to react as things are happening, or to provide defense so that you don't allow those things to happen. So here are the few things that we're going to talk about as your lines of defense. We're going to go over hiring, your actual workplace violence policy, training of your management and supervisors, security and threat assessment, investigation of complaints, recognition of red flags in the workplace, maybe some of those predictors that we talked about in the first example, how to engage in proper terminations, and then regulation of weapons in the workplace. So that is our overview for the remainder of our time together. So let's jump in. First line of defense is hiring. You've heard that expression, junk in, junk out. Well, that may sound harsh when you think about it, talking about personnel, but I think it can apply. If you don't do the hard work on the front end to hire appropriately, then you end up getting people into your workforce that perhaps are going to cause you trouble later on, and it's much harder to get them out. So it's better to take the effort and the time on the front end to make sure you engage in responsible and effective hiring practices. So here are a few tips that I'm going to offer to you on the hiring front with an eye towards workplace violence. So really this applies to any hiring, but particularly with workplace violence issues. You want to carefully review job applications and resumes. It's not uncommon that you post a position and you may get hundreds of resumes. I've seen it happen. And it's hard to spend time going through all of them, but it's important that you do that and you have a vetting process. You want to note questions that applicants fail to answer or that might be incomplete. That should be a red flag for you because maybe there's something they don't want to tell you there or something that they're hiding. Note suspicious reasons for leaving past employers. So it's important that you have a question as to their employment history, but then also a reason for leaving section so that they have to tell you why did they leave that past employer. And that could be important later when you check with those references to see if the reasons actually match up. Obtain permission to contact previous employers, law enforcement agencies, and so on as a part of a background check. So you want to have a consent to that as part of your application process. And also, I think it's really important to have a statement on your application that states that they are verifying the truth and correctness of the information on their application, and notify them that if you falsify the application, that will be grounds for termination. I have had many a termination occur when an employee is performing poorly, things aren't going well, but we go back and look at the personnel file and we realize that there's some untruthfulness in the application, and many times we can rely on that statement and that could be the grounds for termination, and it's clean and clear, and that could be very helpful in a situation if you have an employee in the workforce that is giving you off some red flags. If you have that and you find that there's untruthful statements, then you can rely on that application process. A few more things about hiring. I think it's important to conduct face-to-face job interviews. Now, that's hard to say in today's world. You may not be having people come in to hire for hiring into the workplace and do face-to-face interviews. You may be doing Zoom meetings. Well, I still think that's somewhat of a face-to-face. I think it's important to have that visual recognition and not always just a phone call, and certainly not just off paper. You can pick up on a lot of cues from people when you have time with them one-on-one. And so I think face-to-face interviews, Zoom or in person, are important. It's really important in my mind to protect against workplace violence to make sure you check references. Contact the applicant's references, ask good questions. Don't just say, how was the employee? You need to ask very specific. Was the employee typically on time? Were they dependable? Ask very specific questions. Now, you know that very often, and this is my advice, at least to my county and city clients, is if someone calls, I tell them, look, you're not going to talk about the employee. You're just going to confirm the hire date, the separation date, the position, and the salary, because we don't want to engage in talking that could then cause additional problems. That may be the kind of responses you get. And if that's the case, remember that if you're looking at a candidate from another workplace and local government, you can make an Open Records Act request for that employee's personnel file. And if it's a high-level position or you have any red flags for an employee, then I recommend you do that. It's a simple thing to do. You should have a response in 3 days, and it'll tell you a lot if you're not able to get references to be forthcoming with you. Also, performing criminal records or background checks. I think it's important to do that depending on particularly what your position is. Now, we'll tell you there's some landmines in this area, so if this is not something you typically do or you have not vetted a policy or process, then you should talk to your county or city attorney or inquire of us through the helpline, because if you don't do it right, you could be subject to discrimination claims. So you should never have a blanket policy that says if you've been convicted of any crime, you will never be hired for any position. You want to be careful that you're considering each response. If you ask the question and engage in a criminal background check, that you consider each result and each response individually and with respect to not only the position and how that potential crime might relate to the position, but also the nature and gravity of the crime, and then how long ago was it? Those are the kinds of things that EEOC guidance would tell us if you have these blanket prohibitions, or if you're willing to look at a criminal traffic offense from 20 years ago to preclude employment, that you could then be discriminating against people. So it's important. It's a good way to ferret out problematic employees and concerns for workplace violence, but you have to be very conscious that it's not imposed in a discriminatory manner. Also, to that same line of thinking, drug testing as appropriate. Typically, this will be with safety-sensitive positions. You want to do that and then follow through that process through your testing agency. Now, I will tell you that with all of these grand and glorious and important hiring tips that I'm offering you, that you can do everything right, and you may still not have a great result. And I'm going to tell you, I'll admit to you, I'm case in point. And I'm almost embarrassed to admit this to you since I'm here teaching you how to do it, but I'm going to do it. I'm going to be transparent. So I had a situation in my office that I guess it's been a couple years ago now, and I was the primary person managing the hiring through my HR folks in my office. And I won't call names, of course, but I went through an application process, went through an interview process, did face-to-face interviews. We did background checks. I personally spoke to multiple references. Everything checked out great. And I hired a CFO. The current state of that employment relationship is that it's been severed. The individual's been indicted just recently for stealing from me lots of money, and also from the Cub Scouts, interestingly. So I look at this and my kids laugh and say, I can't believe you teach this stuff when you did it all wrong. Well, I did it all right and still ended up with a bad result. So, I think it's important to do it the right way, but I can't tell you that you're always going to get it right, because sometimes things just escape detection, and that was the situation in my case. I hope it won't be a situation for you, but I didn't have any violence issues. So that's the high point there in that story. So let's go to our second line of defense. You need a policy. If you don't have a workplace violence policy and a weapons policy, I highly recommend that you have one. I have sent not only this PowerPoint, but also a sample policy out to Dan, and I'm sure he'll be sharing that with you if he has not already. I laughed and told him I didn't know if he wanted to share it beforehand, because if he did, then none of you might attend this little webinar. And so he may be holding it back as a carrot for later, but I'm going to give you a sample policy that you can utilize if you wish. You may have a perfectly suitable policy in place, but if you don't have anything, I think you should have something. And I'm going to go through some basics on what I think that policy should include. It should have a definition of workplace violence, and it should offer examples of the kinds of conduct that would be sought to be prevented or prohibited through the policy. Now, the Occupational Safety and Health Organization defines workplace violence as this: the act or threat of violence ranging from verbal abuse to physical assaults directed toward people at work or on duty. Very basic, very simple, very understandable. Here's another, maybe a little bit more broadly stated definition that I've seen in government policies. And it sounds a little bit more like perhaps your discriminatory harassment or your sexual harassment policies. Any conduct that is severe, offensive, or intimidating enough to make an individual reasonably fear for his or her personal safety or the safety of family, friends, or property. So there's not a lot of magic in the definition. You just want to make sure that it's as objectively stated as possible so that you can actually apply it. And I'm offering you some very specific language here. Again, you can look at my sample policy, or you can utilize some of this language that I'm sharing in the PowerPoint, which will also go out to you if you haven't received it yet. So you could build this into your own policy if you wish. But I think not only is the definition important, but I think giving some prohibited examples of conduct, I think that's helpful so people can understand what it is we're seeking to prohibit. So here are some examples that you might list as conduct that is prohibited by your policy. I think the good thing about the examples as well is that people can't say, oh, I had no idea that that would be a violation. You've given some clear examples here. So the first would be threats or acts of violence or behavior. And again, there's always this reasonable fear, this reasonable standard, fear or intimidation that occur on the employer's premises. So a lot of workplace violence issues may not occur exactly in the workplace. And we'll talk about that a little bit more later. But you want to have as an example that it occurs on the workplace premises. And I also want to mention this. While there might be a reasonable fear or intimidation based upon what is said or threats or acts between people, it could also be based upon how an individual engages with property. I had some video clips that I almost included in my PowerPoint today. And my paralegal said, she kind of talked me out of it because they were a little bit graphic, but I didn't want to offend anybody. But I can tell you, if you get on YouTube, you'll see some pretty crazy stuff and things where people are just taking, laptops and just throwing them at people, or pushing over file cabinets, or throwing a stapler, or just throwing files up in the air. Those are all issues that, depending on how they occur, could indeed be a conduct that should be prohibited, and at a minimum, it should be a red flag if you've got someone destroying property in the office, even if it's not a person-to-person kind of threat, that's still threatening behavior. Now, this next example of conduct that you could include in your policy would be threats or acts of violence or behavior that cause a reasonable fear or intimidation that occurs off the premises. So this would be like that example I gave you earlier, where there's an altercation off the work premises. The employee is maybe there as a representative of the employer, or maybe not, or maybe the employee is going out, and it's purely social, but the relationship between the two people is based upon the workplace. Those are things that if the employee comes in and reports them, I think you should be willing to listen to. Maybe not for a disciplinary action per se, because it occurred off premises, unless indeed they were your representative there, whether it be, on the scene, issuing a permit, doing an inspection, or any number of things like that, they could be a county representative. And if they engage in inappropriate behavior off premises, then certainly that's disciplinary basis. But maybe it's not that kind of setting. Maybe it's just an employee-employee situation, like the fist fight between those two gentlemen that happened the day before there was the workplace shooting. Those are situations where you should listen and you should be willing to address them, even if it's not from a disciplinary standpoint, but maybe from a safety standpoint. And we'll talk about what some of those responses might be in just a bit. A last level of examples that you might give are sort of a string of things here that I've listed. I won't talk through every single one of them, but you'll have them in your materials. I want to highlight some of them that may not be as intuitive. Obviously, if someone's threatening, screaming, yelling at you in the workplace, that would be apparent, prohibited conduct. Obviously, if somebody touches you in the workplace in an intimidating, physical, or aggressive manner, then that, again, would be pretty obvious. But what about, threats to your property? I'm going to burn your house down, or I'm going to let the air out of your tires, or what if some of those things happen? That might not be as evident, but I think those are certainly viable issues that give rise to workplace violence considerations. Nowadays, not only is the verbal word very dangerous, but the written, whether it be in written or electronic communications, social media posts, sometimes that's where people get behind a keyboard and they feel very comfortable to say things and do things they would not do in person. And many times those can be threatening or inappropriate in ways that you may want to consider it from a workplace violence protection standpoint. Looking here at a few more things on those lists of examples. Stalking. I've seen that be in the workplace. I've had employees accuse, supervisors of following them around, following them to the bathroom, following them through the halls. Many times that's giving rise to more of a sexual harassment kind of complaint. But depending on the behavior, it could also be perceived as a safety issue. So be looking out for that. And also, I note another one here that you may not think about, but like an endorsement of the use of firearms, of weapons in an inappropriate way. Certainly, there's the Second Amendment, and we're in the state of Georgia. A lot of people talk about use of firearms. I'm not saying that that is a red flag or workplace violence issue, but if someone is communicating some kind of inappropriate use, I'm going to hide my gun, I'm going to pull it out at the movie theater, those kinds of things, then you may need to be aware of that. And that's why having these things in the examples also puts your employees on notice to be aware and watching not only for how they behave, but how others behave around them. Now, weapons and defining weapons is a big part of your ability to enforce anything under this policy related to the unauthorized use or possession of weapons. At the very end of the presentation, I'm going to talk to you about the rules about how we can regulate weapons in the workplace, but I think your policy needs to define what that means. Again, I'm not going to try your patience by reading all these to you. There's the obvious things like guns and knives. There's a lot of things in this technical definition that I see in many policies that I don't even know exactly what they are, to be honest, but brass knuckles, I do know what bows and crossbows are, but throwing stars, nunchucks, I mean, those are things I see in the movies. I don't think I've ever seen them in person, but those are all things that should be defined as a weapon. Interestingly, also on this list typically is even self-defense chemical sprays, if they're in a large enough canister, larger than 2 ounces, so that it's clear that it's not just for personal protection, but it could be used as an offensive weapon. Tasers and stun guns. Now, again, there may be some approvals by the city or county manager because of the type of position they're in. But otherwise, I think having a listing of what you would consider to be concerning items to be in the workplace is an important part of your policy. One of the examples that I ended up not showing you by video, but you can Google it on YouTube, was an individual who did have actually got a fire extinguisher. Now, that's not necessarily on the list as a weapon, but use that as a weapon by just spraying that in a coworker's face, just like close range. And, you know, that's not exactly the equivalent of a mace or a pepper spray, but it was used as a weapon. So there's also the option for things that aren't traditional weapons to be used as a weapon. Again, those are the kind of things you can't always provide for or anticipate. Another point that I just want to mention to you that could be included in your statement of what constitutes workplace violence as a matter of defining this issue is domestic violence. Here's a very detailed definition that you can take a look at, but I do see this come into the workplace a fair amount. Many times, you know, there's a situation where the employee may be a battered spouse and the, you know, aggressor spouse is coming into the workplace or waiting to pick up the person, and so is stepping onto the premises. Those kind of domestic violence type issues can permeate the workplace in a manner that you need to be aware of what's going on. You need to be able to address it. You need to protect your other employees. So it's not always about just protecting the intended target or victim, which would typically be the case in domestic violence type behavior in the workplace, but protecting those around who would be the attendant, you know, sufferers of any kind of harm that might occur. So it's not about just the one-on-one violence, but it's about all of what might happen with the coworkers that are around that intended target. And that's where your job is to protect everyone. Now, looking just a little deeper into the policy, to this point, I've talked to you about really definitional issues in the policy. Now, this is what I call the Super 7. These are my top recommended policy provisions outside of having your good definitions. So once you've got your definitions covered, here are the other things that I think you must have in a policy to make sure that you're covering it adequately and then clearly enough to enforce it. So you need to say in your policy, when do you report a violation? You need to say to whom the violation should be reported. You need to provide how it should be reported, give a process. You need to state affirmatively that all complaints will be taken seriously. I think that's important so your employees trust that you will take seriously the complaints that they bring you and carry it forward for consideration. You need to provide that all complaints will be investigated and that all complaints will be treated with confidentiality as much as possible. We all know that's not always completely possible, but you will want to maintain confidentiality and state that you will to the extent reasonably possible. And then finally, that there's no retaliation that will be engaged in as a result of someone coming forward and making a good faith claim. And I'll talk about these just a little bit more. So in my Super 7, number 1, your policy needs to say when to report, and it should be immediately. Workplace violence is not your typical thing that you want to, be brewing and bubbling and continue. One of those examples, that I mentioned about the 2 individuals where they had the fist fight and then the next morning he comes and shoots the coworker. It was known that there was this long-standing feud between these 2 individuals. They had words in the workplace. There was a lot of aggression throughout the work history, and it was well known. So somebody should have been reporting that. Somebody should have been picking up on that. Doesn't mean necessarily there's disciplinary action, but maybe there's, separation of the employees to different work sites. Maybe there is anger management through an EAP, but just shouldn't be ignored because obviously those kind of things festered. So immediate report. And I think it's important too that similar to sexual harassment and other policies that you have, that they're encouraged to come as quickly as possible and to report as quickly as possible, but I would not dismiss a late report. So just if someone comes to you and says, this happened last month, I've been thinking about it, I decided to come forward. Well, if your policy says immediately report and they don't, I wouldn't say, oops, sorry, you're out. Because for some people, it may be an issue that they're not comfortable coming forward quickly. But I think your policy should say that they should. Who do they report to? Just like with sexual harassment or discriminatory harassment, I think it's important to have reporting avenues. So ideally, you would report to your immediate supervisor. But, sometimes it's the supervisor who's involved. And so if that's the case, you need to give them some selections of options to report. So I think the HR department is an obvious example of someone that should be a reporting option. And then maybe even a department head. So if that person needs to go around their supervisor, now that would tend to be a chain of command violation, which if you're in a sheriff's office or the fire department, that's a much more serious thing than in your typical general administrative positions. But again, you need some reporting options because if the supervisor is the problem, then you want to give this person options to get around the problem person so that they can make a fair report. How should you report it? I wouldn't get hung up on that. It could be verbal, it could be in writing. If you get it verbally, you should document as much as possible in writing so that you have that in the file. But I would not refuse to take a verbal report just because in the essence of these kinds of issues, it could be serious and you don't want to dismiss something out of hand. Also think about whether it's an issue that requires involvement of higher ups, whether you need to go to law enforcement, whether you need to call 911. If someone reports a complaint and it's serious enough, Joe has a gun, he's holding out in the hallway, well, then you're not going to say, okay, well, let's sit down and let's document that. Here's my interview process. Obviously not. I don't think anyone would do that. But it goes without saying, you need to provide in your policy that you can, shortchange your process and do what you think needs to be done to protect everyone in the workplace, which may mean a quick call to 911. I think the policy also is one of my top 7 items for inclusion should include consequences for violation. So it needs to be clear that this is a policy that's for protection, but it's also a policy that's for discipline. So if you violate the policy, you could have language as simple as if you violate it, you're subject to termination up to disciplinary action up to and including termination. It can be that simple, but I've seen people get caught up before on having policies that don't necessarily include consequences. And then when the employer tries to discipline on that, they use that as sort of a splitting hairs opportunity to try to escape the disciplinary action. So just state what the consequences would be in your policy. I think it's also important to state that there's a requirement to cooperate. It's not an option. So if someone's called in to testify or be interviewed as a witness, they don't have an option of saying, no, I'd prefer not to come and have that meeting. I don't want to sit for an interview. If they don't cooperate, I think that could be stated and should be stated as also a violation of policy, because if people aren't willing to cooperate with your investigations and with your complaints, then they in and of themselves are contributing to potential workplace violence issues. Also, as I mentioned in my Super 7, retaliation is important to address. You want to make sure that an employee's not scared to come forward, because maybe not even afraid that they're going to be a victim of this perpetrator, but maybe afraid that, hey, you know what, if the perpetrator is my boss, or the perpetrator is maybe somebody very popular in the workplace, but also very violent, then I'm afraid that I am going to be, harmed by that. Okay, I don't know what in the world just happened to my slides. There we go. Not sure what happened there. So I think it's important to have a retaliation provision that assures employees that they can come forward and have a free and fair opportunity to report with no negative consequences if they're making a good faith report. And in fact, if anyone retaliates, then that needs to be stated as also a disciplinary measure under the policy. I want to mention just quickly about how important the policy could possibly be as the defense, not just a line of defense, but the defense. There's something under the law, it's a Supreme Court case called Farragher and Ellerth, and it's referred to as the Farragher-Ellerth defense. You probably have heard about this in the sexual harassment context. There's not a case that's ever directly addressed this in the context of workplace violence, but I want to mention it to you because I think it could conceivably be raised as a defense. I would raise it if I had a claim by an employee who sues my county or city and says, I'm suing you because you didn't protect me in the workplace. Well, if I could show that I had a solid policy and they didn't take advantage of the policy, then I would raise that as a defense under the Farragher-Ellerth standard. So I just want to mention this for a second. It's typically used in the terms of hostile workplace environment in a sexual harassment context or discriminatory harassment context. But here's the standard. It's a two-part test. And now it would not apply if there's some tangible action against the employee, like the employee's been fired or demoted. But in the typical claim that comes in workplace violence, it's going to be a claim like, I wasn't adequately protected. You didn't discipline the other person, and you allowed these bad things to happen in the workplace. So if there's no tangible action against the claimant, then here's your two-part test under Farragher-Ellerth. First question would be, did the employer exercise reasonable care to prevent and correct promptly any harassing or violent behavior? And then number two, did the plaintiff, the claimant, unreasonably fail to take advantage of any preventative or corrective opportunities that are put in place by the employer that might have allowed them to avoid the harm? So the way it breaks down is this. For part one of the test, if we can show that there's a workplace violence policy that's well disseminated among the employees, everybody gets a copy of it, best practices would be everybody signs off on it when they receive it. The policy contains reasonable provisions, particularly the Super 7 that I mentioned. The policy is effective and applied, and that we took prompt action if there's ever been any kind of complaints. And that really should meet the first prong of this test. The second prong would be that the employee failed to take advantage. So if you've got a good workplace violence policy and you've got someone who wants to be a plaintiff against you and they didn't report under the policy, then that could be a complete bar to that claim. Now I say could be again because this has not been litigated to my knowledge in a reported case, but it's a defense that I would make. And I wanted to raise it because as we're talking about lines of defense, I think your policy could be the defense and a complete bar to claims if you are able to establish these 2 points. Okay, we've talked about some do's, and here's a few do nots. So do not include profiling in your policy. I have seen some policies that, as a matter of, I think, a good faith intention to alert maybe people or their coworkers to issues in the workplace that could become violent, they may say, if anybody comes in a hoodie, you can't be dressed in a hoodie, or if you, just various things that are characteristically potentially aimed at those in other races or genders or ethnicities. That is not appropriate in your policy. Don't try to profile. It's not of much value, for one, because you saw that first example, it was the certified professional engineer with a spotless work record. So it doesn't really add value because you don't know always who is going to have that violent behavior. But it's extremely problematic in light of anti-discrimination laws. So use caution to identify the behaviors. That's why I wanted to go through many of those examples of conduct that would violate the policy. Focus on the behaviors and not the people or the protected classification. Another do not, and this may sound counterintuitive to you, but I think it's problematic to include a zero tolerance policy. I wouldn't do it. You've seen some crazy, probably examples, I've seen them on the news, of these zero tolerance policies in schools, where a little kindergartner brings, a little toy, figurine that's holding a sword, and they get suspended for 2 weeks or kicked out of school. Those are the kind of unrealistic and maybe unreasonable events that could occur if you have a zero tolerance policy. Here are some of the other things you have to worry about. If you have zero tolerance, it could be completely in contradiction to your progressive discipline policy in your handbook. Now, most progressive discipline policies will say, we can skip steps, as you should, if something is sufficient and substantial enough. So obviously, if someone's brandishing a gun in the workplace, we're not going to say, okay, we're going to start with verbal counseling and you get to do this 5 times until we terminate you. Not going to do that. So progressive discipline obviously has its place, and then it has its place for when it doesn't apply. But here what I'm suggesting is if you have a zero tolerance, then it could be any small type of issue that happens. Maybe someone said what would be perceived as fighting words, or maybe somebody did, push a file off the desk because they were upset. Well, does that mean they get fired? If you got a zero tolerance policy, the answer would be yes, and maybe that's not appropriate. It could be subject to abuse and manipulation by management. I mean, you could have some managers who try to bait people into engaging in some fighting words or into some kind of physical act in the office. And if it's zero tolerance, then that would lead to an immediate termination every time. It also doesn't leave room for consideration of maybe misunderstanding or even cultural diversity. There may be something that could happen in the workplace that would be offensive and perceived as maybe dangerous or a red flag to some, but perhaps when viewed reasonably or objectively or through a different cultural lens, it's not. And so again, a zero tolerance policy wouldn't allow for those kinds of considerations. And then here's what I have seen is folks who have a zero tolerance policy, I'll always ask the question, well, have you applied it every time like that? And usually the answer is no. And so if you've got zero tolerance, it really sets you up for discrimination complaints in that way as well, that you didn't apply it uniformly, and perhaps you violated equal protection of some of your employees because you did not apply it equally. Let's jump into the third line of defense, and that is training. And I see it's already almost 2:45, so I'm going to start moving a little more quickly, but I want to take some questions at the end, so I'm going to start hopping here. But the third line of defense is training. Train your managers to be willing to conduct accurate performance evaluations, to deal with things as they come up. And that is an important thing under any aspect of HR, and I'm sure you struggle with that in your daily HR practice, but good training on evaluations is important, and very many times it can nip issues in the bud. It's also important, there's some good classes out there on conflict avoidance and resolution. Those are great training opportunities for high-level management. Many times when I see these things that have festered up to the point of exploding, I do hear that it was really a manager who was not hands-on, a manager who was happy to turn the other way, didn't want to deal with disputes in the office, didn't want to deal with complaints, things get ignored, they fester, and then they blow up to higher problems. So all of that training can really assist you in protecting your workplace and avoiding claims. Now, the fourth line of defense is more of a risk management perspective, but do a security and threat assessment, because, while we're trying to deal with the people and the employees and looking at how they can impact us in the workplace, there's also these non-personal issues that's just simply how your workplace is constructed and how you have security that can also be further protections. I'm not going to talk about that to a great degree because that, again, is a little more of a risk management function, but I think it's an important aspect for your consideration when you talk about workplace violence. Having some controlled access to the perimeter and the premises is important. You can use security cameras. There's been some debate about security cameras that have visual and audio. I don't recommend the audio necessarily because there's been some complaints about, the federal wiretapping laws. If someone doesn't know they're being auditorily recorded, that could be a problem. As a government, any of these things are viewed as a Fourth Amendment search issue. If you've got a camera, you want to make sure that the person doesn't have a reasonable sense of privacy in whatever area that you're videoing. But typically that's easily rectified if they're in plain view. You may need to upgrade lighting so that folks aren't going out, especially if you have different night shifts like parks employees or law enforcement employees. Enhance your lighting so that you don't have opportunities for employees to lay in wait and to have things happen in parking lots or off, the outside of the premises. Active shooter drills can be done. And consideration of alarm systems, metal detectors, and screening at entrances. All of those things are just your general security and threat assessment that can go a really long way to protecting you against not only the people outside, but the people who are coming inside to work for you every day.
Hey, Angela, before you go to the next slide, I have a question, if I might. If an incident occurs and you find out later time that it occurred, but was not provided to you, how should it be handled? So again, it's kind of late reporting of an incident.
Yeah, I think you still take it up. I mean, I think I see this happen even sometimes in sexual harassment or discriminatory harassment issues. And even though you have a policy that says report immediately, if you find out about something and you determine that it's legitimate, it's not gossip, it's objectively an issue, then I think you do need to commence an investigation. I think that's important. Now, if the employee against whom the complaint is made or discovered is no longer an employee, then obviously you probably have little reason to pursue that unless you need to see why your policies broke down and why reporting was not made. But otherwise, I would say you take it up, because just because something happened a month ago, it may be building up to where the big issue is going to happen the next day. And so you can really maybe preclude some problems and keep your employees safe by making sure you don't dismiss any complaints at all.
Very good. Thank you.
Yes, sir. Fifth line of defense is investigating the complaint. Now, we've talked about having the policy and taking the complaint in. Well, investigating the complaint is very important, because if you have a great policy and you take the complaint, but you don't handle it appropriately, then that's where everything kind of falls apart. The wheels come off the cart. So investigating is important. And that's what a lot of people, I think, struggle with. This is something that could be done through your HR department, through the manager, or it could be done. I see some governments who like to utilize like an IA department in their sheriff or the fire department, because those folks are very used to conducting investigations. And frankly, if it's a workplace violence issue that rises to the level of security concerns, it's not terribly inappropriate to have someone like that do it. I would be careful that you're not ratcheting it up to a law enforcement investigation unless you deem it appropriate just to refer it out to the sheriff. Otherwise, I think I would make sure you're doing the investigation as you would other investigations, whether you use an IA group or whether you do it with HR. But there are going to be those times you need to refer it out. And there's also an option that you refer it out to a private investigative company if you think it's big enough. I do investigations all the time on personnel issues or a variety of different things, and that's something that you can always refer out as well. But typically, I'm expecting this is going to be done by HR. So when you get the complaint in the Human Resources Department, here's sort of a list of questions that I think is a good checklist as you're gathering the basic information. And again, I feel that we're kind of running short on time, so I'm not going to go through all the questions, but obviously you just have to vet from the complainant what happened and who's involved. Now, I put a big stop sign here because I would say, remember, this isn't necessarily your typical complaint. It's not like an administrative issue, like this employee's chronically late, this employee's made all these mistakes on her paperwork, this employee, even sexual harassment or discriminatory harassment. Those kind of issues don't necessarily implicate loss of life. Workplace violence could mean loss of life. So you need to sort of see the stop sign and make sure you don't go too far down the road of your typical investigation if there's a need for an immediate safety assessment. So you may hear something and there may need to be a decision made that you immediately put that potential perpetrator out on administrative leave. You know, no stigma, it's paid leave, but put them out so that there's no risk. Make that decision really early on as to whether you think there's an immediate risk and you need to kind of take a stop and a timeout and do that safety assessment. Don't get lost in the minutia of an investigation if you need to make a big decision early on. As you're investigating it, you know, you need to interview people, and it's uncomfortable sometimes, but many times it's the only way to know what's occurred. You want to interview the witnesses who are identified by the complainant. Obviously, you're going to interview the accused. I recommend doing that last. And then you may need to consider a follow-up interview with the complainant if you're hearing from witnesses and from the accused in ways that contradict what the complainant told you. Then maybe you start looking at that and say, maybe it's not a legitimate complaint. You need to go back and ask some more questions. As you proceed through the investigation, you know, what might your response to that be? So you've gone through the process, you've come up with your conclusions. It may be at the end of the investigation, then you make a safety assessment and decide leave for further investigations appropriate. You may then apply no contact rules. You know, as I mentioned, those two individuals who had the fist fight and then they had a gunfight the next day at work, if early on there had been some no contact rules or some movement of those two people to be in different locations, you know, different home bases for the city, those might have prevented the problems. You know, what remedial action should be taken? Should the person be referred to some kind of anger management training through EAP or otherwise? Or is there some other potential remedial action or services that's needed? Maybe it's not only a no contact, but maybe it's a change of shift. Maybe it's a change of reporting or change of positions. You know, if someone's an administrative professional in the public works department and there's an issue there between two people, then maybe you move that person and they take the administrative position in the planning department. So don't really take anything off the table when it comes to trying to remove people that may have some contentious conduct towards each other. And then ultimately, you know, the response to the investigation may be a disciplinary action. And I'm going to talk about that in just a little bit as well. Confidentiality is king. It's important for a couple reasons. Always HR is important to be confidential. I'm sure you know that. I think that's sort of a, you know, top line rule in HR. Keep things confidential. But consider the fact that you may have some medical issues involved. I mean, if someone literally is having some mental instability, it could be a medical issue. You could have privacy issues involved if it involves, you know, domestic violence situations at home or any number of other things. So think about these as sort of your be ultra careful medical privacy type thing when you're talking about confidentiality. Also, treating this as confidentiality will also make sure that you don't escalate the situation. I mean, if you've got someone that's already a live wire, letting it get out that that person's being investigated is going to only exasperate the individual. It could cause more disruption. It also can create some retaliation potential. I want to speak briefly on searches. There's two ways you can view searches. Some workplaces will just rely on the idea that they're going to request permission to search. So if you get a report that someone, you know, was sharpening a knife at their desk, and you go to see if that's happening and you don't see anything, well, are you going to just rely on the fact that you're going to ask that person to search their desk? Some folks do it that way. My strong recommendation is that your policies state somewhere, generally usually in your general employee handbook policies, that there's no expectation of privacy in the workplace with respect to the property of the employer. Some will even say, post signs saying no expectation of privacy in your purse and your briefcase and so on. I don't see that very often. I think that makes me slightly uncomfortable. But I think saying there's no expectation of privacy to information on your county issued computer or your city issued desk, or any of those things, or the vehicle issued by the city, then you can search without consent or without notice. And so I really recommend having that. And again, generally that might not be in your workplace violence policy, but just in your general handbook policies. Sixth line of defense would be to recognize the red flags. You know, I've mentioned quite a few of them here. I won't read them all to you. Most of these I think are intuitive, but it may be intuitively recognized, but not really considered or addressed. And so that's where I think the training for your management folks come in, and then you as HR as well, being able to note that someone may come in and make a very benign comment or a benign complaint, but you see it as a potential red flag for something that may be more significant and foreshadowing something in the future. Now, if you have these red flags reported, many times it can be a very friendly employee assistance program referral. Please, if you've got those resources, use them. It could be a great deflector of issues and preventative, but it also could be a good post-incident tool. So those EAP programs can really, really be useful in this context. And sending someone when you see a red flag sometimes can be a lifeline for those people, and then certainly for your workplace as well. All right, danger, danger, danger. So we've talked about wanting to regulate these issues and this conduct. We see red flags. We want to snatch people out and say, okay, you're a danger, you're a risk to the workplace. What do we have to worry about, though, from the HR perspective? What's that claim coming at us? Because I feel like that's the world we live in, right? What's the lawsuit going to be? Well, the Americans with Disabilities Act is the biggest thing that really is in play here. If there's mental illness, not just someone's on a bad mood and got a temper, but true mental illness, then that is a disability. The ADA, as you know, prohibits discrimination against employees based on an actual or a perceived disability, and mental illness is included within the definition specifically of disability. So you have to be careful with these issues. And so if you believe that there is a mental illness component to this, then I am going to say consult with your counsel, because you're getting into really treacherous waters and you want to be very careful. You can always send an employee in that kind of setting to a fitness for duty exam. I see this happen a lot in the law enforcement context, where either there's some real anger issues, or even there's just been, an officer involved shooting, and they'll send them for fit for duty or a psych review because of what they've been exposed to. Those are permissible. However, generally the ADA says you cannot do just general medical exams as a general course of employment practice, that's discriminatory. So I can't just pick and choose and say, I want you to go see the doctor tomorrow. You have to be able to show that there's a reasonable threat of harm. You have a good reason to believe there's some threat of harm, and that the exam would be job related and consistent with business necessity. So again, there's some landmines here. So if you believe mental illness is in play, fitness for duty is an option for you, but you might consider consulting with counsel just to make sure that you check the boxes and protect yourself from any kind of disability claim. The other issue that can come up under the ADA is maybe you realize that this employee presents what's defined as a direct threat under the Act. And that happens sometimes, where someone has engaged in such volatile behavior or done some things perhaps that you believe they immediately need to be removed. That's permissible as a termination or as a removal from the workplace if the employer shows it's a direct threat. The things that have to be considered under that standard is the duration of the risk, whether there's the nature and severity of the potential harm that would be in play, the likelihood the harm could occur, and then the imminence is an immediate situation that this person needs to be removed, whether for fit for duty or removed permanently from the workplace. Now, with any ADA issue, you have to consider a reasonable accommodation, but typically in these settings, there's not usually a reasonable accommodation if there's a direct threat in the workplace violence context, but that should all be considered with legal counsel to be sure that you don't try to correct one problem and create yourself another problem by drawing an ADA claim. Here's our seventh line of defense, and that's termination. So we've gone through all of the process, we've done the investigation, and we determined that we're going to terminate an employee because of something that's happened in this workplace context. Well, that may be solving your problem. You may think, okay, I've got this violent employee, I'm going to fire them and get them out. The problem is, does that employee that you terminate come back the next day and shoot up your workplace, right? So the termination might not be the end of solving your problem. It could be sort of the beginning of creating the next problem in the workplace violence context. So you have to be very careful about how you handle terminations with these types of individuals. Here are a few practice pointers. Don't meet alone. And that's HR 101. You should always have another manager with you. So it's not only for safety, but it's also for reporting purposes and just for HR protocols. You should alert the victim, and ideally, if there's a targeted victim, have them not in the workplace when this is occurring, and maybe not in the workplace the next day or so afterwards. Provide security if that's needed at either the location where the employee works, or for them privately if you believe that that's really necessary and appropriate. I think it's always a good idea in these situations to have law enforcement or your security on call. You know, maybe when you call the employee in to have the meeting, you have law enforcement, you know, staged at the door, or at least on alert. You want to assess your threat when you're having your termination meeting. You know, if the employee is sitting there with just clenched fist and they're cussing left and right and they're violent, they're coming across the table, then those are the kind of things where you need to be able to hit a button and ask for someone to come in and assist. So beware of those threats and how that termination is being perceived by the employee. You should conduct the termination quickly once the decision's made. Pick a good time and place. You know, don't do it in the middle of the day when the entire workforce is humming with people at their desk. I think it's important if it's a small location and you can let people go early that day and bring someone in at 4:30 or 4:45, I think that's ideal. You want to try to minimize the number of people who are in your workplace when you do such a termination. Keep the meeting short. Don't debate or argue that anything that's going to fuel the employee's anger. And as much as possible, create the minimization of any interaction that this employee will have with coworkers in the workplace. Here are a few more things to take into consideration. If threats are made during the meeting, then you need to take those seriously. You may be removing the employee, but again, that may be just the beginning of the real threat. So make sure you take that seriously, and maybe at that point, it definitely needs to be reported to law enforcement depending on the nature of the threat. But try to preserve the dignity of the employee. So the employee may just be going through some stuff and may have lost his mind and done bad things in the workplace, but he's not really a risk, and isolating him or ostracizing him further is going to push him off the deep end. So try to preserve some dignity. Try not to walk the person escorted by law enforcement out the door through the entire workplace. As I said, again, think about the day and time, think about removing people from the workplace so that there's a clear path of in and out that will minimize any kind of contact, so you can be discreet. You also want to alert your security and front desk staff that the individual is no longer employed. Make that known immediately and let them know if the individual shows up, who needs to be contacted. You don't want them just to hop in and nobody realize that they walked by the front desk because they're a familiar face, and then all of a sudden they're within your workplace undetected and you're unprotected. Ensure the terminated employee is able to get home safely. You know, if it's somebody that you know to carpools, you know, make sure that you've thought that through. Think through the process of getting the person home. Think through the process of getting their desk cleaned out, and getting return of property. I always think it's important when you go in a termination meeting, really any termination meeting, that IT has been alerted that, hey, at 4:05, shut down their passcodes, shut down their passwords on the computer, shut down their identification badges, so that, you know, in an instant, their access is gone while they're in the meeting. And then consider whether a restraining order or a protective order would be necessary. Again, that would be the kind of thing where you're referring it further to law enforcement, and maybe you've heard additional threats during the meeting. So all of that's to try to ensure that the termination doesn't cause you more problems. The other way you want to try to minimize your problems in the workplace is by appropriate regulation of weapons. And this is the final issue I'm going to talk to you about today, real quickly. In this era of Second Amendment, and there's a lot of state regulation on weapons, I think employers are very nervous, and understandably so, about what can we do in the realm of weapon regulation that's not going to buy us a lawsuit and not going to cost us some kind of major claim. So there are two big considerations that you have to keep in mind. The state law that regulates firearms, and the state law generally, when they regulate something, it preempts a local government or an employer from regulating it separately. So you have to be concerned with what does the state law say and how far can we go against state law. And generally the answer to that is you cannot. It's preempted. And then there's the Second Amendment to the U.S. Constitution. Now let's take state law first. So the state law gives a carve out specifically for local government. So you've got a statute right on point that allows you to regulate these issues and tells you exactly what you can do. So that's the good news. It's not a huge question mark in this area. Local governments, and here's the statute, may regulate the transport, carrying, or possession of firearms by employees of the local unit of government or by unpaid volunteers of such local unit of government in the course of their employment or volunteer functions with such local unit of government. Now, I want to make a point here. If if you're HR for the county policies cannot necessarily regulate weapons for the sheriff's office or for the DA. There's separate statutes that give them the authority to do those things. And of course, they have different needs for carrying weapons. So just be mindful that when you're doing this, really think about doing this weapon regulation for those employees that are underneath the purview of your administrative board of commissioner type positions. So in short, your weapons policy can do these things. It can prohibit weapons on government property, so they can't bring them into your workplace. You can prohibit weapons in your government vehicles. So if you have issued vehicles for your inspectors or for your planning director or whatever, fire department, if they're government issued vehicles, you can prohibit them from carrying weapons. And you can prohibit weapons at government events. All of this, though, is limited with the caveat that these prohibitions can only be in place while the employee is in the course and scope of duty. So your policy cannot say you can never have a weapon on government property, because if they happen to want to come to a park and state law allows them to be at a park with a weapon with appropriate permit, then you can't preclude that, because that state law has spoken and they preempt the county or city's employer's ability to change that state law. So it has to be regulation just while they're in the course and scope of duty, either as an employee or as an unpaid volunteer. Your policy cannot, however, prohibit storage of firearms inside private vehicles unless there's a secured parking lot. So unless you have a parking lot where you have to come through a gate, if you did, then you could prohibit storage of firearms within those private vehicles. For most of you, I think, and most governments that I'm aware of, you don't have a secured parking lot, and instead it's just an open parking lot. If that's the case, we can't stop employees who have the proper permits. Obviously, they have to follow all state law. But if they have a proper permit from having a firearm that's concealed and locked inside their private vehicle. You also can't require employees to agree that they can basically violate this. So you can't require an agreement that an employee cannot enter the parking lot when an employee's privately owned vehicle has a firearm if it's locked, out of sight, and the employee has the permit. So that's sort of that, that caution area in terms of private vehicles, and as long as those weapons are properly permitted and they're locked securely. Here's a few more details on what weapons policies cannot do. You can't search privately owned cars in unsecured parking lots except under these limited circumstances. But here's a big caveat. Even though an employee can keep a firearm locked in their private car on an unsecured private parking lot for the employer, the public employer can prohibit this. You can't stop the employee from brandishing that weapon, outside of his car, displaying the weapon, propping up in the back of his pickup truck and sitting with his gun, held up. You can stop those kind of things. And you can prohibit an employee from identifying the location of the firearm. So you have an employee that's talking in the workplace. I mean, this would be sort of one of those conduct issues where maybe they're, sort of threatening, saying, well, I've got my gun in the car and I'll tell you where it is. Those kind of things could be prohibited, but we just can't prohibit them from keeping that gun in the locked car if they're properly permitted. Here's a sample weapons policy. This sample weapons policy also is included in the sample workplace policy that I'm providing to you through Dan. So you can pick it up either through the PowerPoint here or through the policy that's coming out to you later from Mr. Beck. Quickly, Second Amendment, here's a couple of considerations for how you evaluate if there's a Second Amendment challenge. But let me just say this to you. If you follow really what I've told you thus far with state law and have these limited regulations on weapons, you're not going to run afoul of the Second Amendment. There's been cases that have found that to be the case. But I did want to include this law for you just to see, to round out the discussion. So here's my sum up, and since I'm a little over an hour, I'm not going to go through it all, but it's my effort at trying to kind of put all of it in a nutshell for you. So I would invite you to read it later when you have an opportunity. But in essence, I've gone through the 8 lines of defense to keep your workplace safe. So some of you who are maybe as old as I am, you remember the old show, 8 is Enough. I hope 8 is enough here. That's enough lines of defenses that will help you keep your workplace safe. I think it all starts with just recognizing the issue and taking the time and attention to address the issue, and that goes a long ways. And I know we're a little over our typical hour that we like to finish within, but I'm happy to take questions if anyone has them now or even later if you'd rather email me.
Any questions for the audience? Is there a time limit to terminate an employee for falsehoods on the job application? Months, years, decades?
No, I don't think so. I think once discovered, it's fine to address it. And I've seen those be done far in arrears, that they discover it much, much later.
Any other questions? Got a great job here, which I would totally agree. Fantastic job, Angela. What else do we have? Any other questions? Well, with that being said, I will be sending out a copy of the PowerPoint presentation, a link to the recording, and the policy that Angela submitted. Thank you so very, very much. Again, great job as always. This is really tremendous for everybody, and we'll go from there.
Thank you so much. Everybody stay safe.
You guys stay safe and healthy, everyone. We will talk to you later. Thank you.
Have a great day.